We're not quite at our start time. We'll give newcomers just another minute. Good afternoon, and let's get started because we've got a lot to go over today. The first thing that we're going to go over, and I'll just throw this up on the board as a roadmap. We're going to go over marking a little bit. Then we're going to talk about the ways in which equitable interests arise. Then we're going to talk about the difference between legal interests and equitable interests. And finally, we're going to talk about equitable remedies. Okay. I've gotten some questions over the course of the semester related to, like, how much is this assignment worth? You know, how are assignments going to be assessed? And every time I get one of these questions, I bristle. It annoys me. And I want to be clear, right? The folks who ask these questions are not doing anything wrong, okay? The problem is here, okay? But I have been thinking more about why these questions rub me the wrong way, right? Why I go every time I get one of these questions. And I think, and I've been doing some reading about this, so this is not just sort of me talking out of my head. There's things to support this. I think that the real issue here is that I don't want to have to grade you at all. I don't think that there's any scheme where I decide how good you are and that's fair, right? This doesn't strike me as a just system, no matter how you design it. And the other thing is that it seems to me that we should be engaged in learning because we think it's worth learning, right? If you're here to learn because you want a particular mark, that feels wrong to me. And it feels like I've failed as a teacher. Like, you should be engaged enough that you want to do this stuff because it's cool. Maybe that's a stretch. But that's what I want, right? And so, like, we are stuck with the system that we have. I am not proposing that we do away with marks and that we do this. I'm not that radical yet. But I do think that we should be honest with one another about what we want out of the class, right? So what I want, what I hope that you guys are on board with is a class where we're focused on learning the material and the marks will come from that, right? And so that's what I'm looking for. If what you're looking for is, you know, what do I have to do to get a particular mark? Well, the best answer I have for you is the best work you possibly can. Yeah, I've provided a little more explanation in the course website under the model answers folder. There's some discussion of tutorial assignments. Jurice, the answer to your question is you haven't missed anything yet. I've just sort of been whining about questions I don't like. And you should feel free to ignore it. Okay, so that's done. I've said what I have to say. I will continue to answer your questions, even if when they come into my inbox, I growl a little. I will continue to answer them. But I hope that you guys will start thinking about what you're getting out of this class beyond just a letter on your transcript. And you'll start asking those kinds of questions as well. Okay. All right. So on to the next topic, which is the ways in which equitable interests arise. And the truth of the matter is that if you have read the assigned reading from Professor Wusu's book, you realize that the vast majority of the assigned reading is talking about this question. How do equitable interests arise? I do not regard this question as nearly as interesting as Professor Owusu does. So he goes through and provides a very exhaustive explanation of all the different ways in which equitable interests arise. I am going to cram it down into four things. Okay? Can you guys read the board here on the chat? Let me know. Okay. I think I probably need to buy more markers, but I have not had a chance to do that. Okay, is that better? It's just 1, 2, 3, 4 right now. So, but is that better? Okay, well, we'll do the best we can, and I'll put things in chat as I throw them up on the board. So the first way in which equitable interests arise is through the creation of a trust, okay? Through the creation of a, oh, there's a glare. Okay. Well, let me. Is that better? Not really. I'm about to pull this down on top of myself. It's going to be bad. It is going to be bad. Better, guys? Better a little. Okay. So, you guys see it in the room? Yeah. Okay. So the first way in which equitable interests arise is through a trust. Okay. And a trust is just a mechanism whereby the owner of the property is not the person who benefits from it. Okay. just a way in which the owner of the property is not the person who benefits from it. So there's a couple of ways that conveyances can be used to create trusts. The common law language, I say common law because it developed out of a, that's ironic because it developed out of a statute, but the common law language is unto and to the trustee for the benefit, sorry, I've screwed this up. Let me start over. I'm sorry. It is unto and to for the use of the trustee for the use of the beneficiary. That's a mouthful, ain't it? Yeah, I can type it in the chat. So I can type that in the chat. Unto and to for the use of trustee for the use of the beneficiary. If this seems like a whole bunch of nonsense, that's because it is. There's a piece missing, okay? This language grew out of the use of a fictional person who did not exist for reasons that Professor Owusu talks about and that are completely not worth your time, okay? So if you're interested and you want to know why a fictional person was used, it's in Professor Owusu's book, but if you are instrumental and you are really just here to get a letter on your transcript, you don't have to read it because nobody cares except Professor Owusu and people who are interested, okay? So over time, this fictional person disappeared from the language, but the grant to them remained. And there are some places in the Caribbean where in order to create a trust, you have to jump through these hoops, okay? Grenada being the one that pops to mind, okay? But in other places, like Barbados or Belize, this has been abolished by statute, okay? And so you can create a trust by just saying to the trustee in trust for the beneficiary, okay? So,
sorry, just to clarify, you're saying in Barbados, that's what's the
in Barbados, you can do this latter because this nonsense, the need for this nonsense has been abolished by statute. Okay. Again, the reasons for it made sense at the time that it was developed because of the specific statutes that were used in England. But it's in a modern system, this is unnecessary, okay? And I would definitely encourage those of you that are from places that haven't abolished this to encourage your elected leaders to do so. Okay. So that's how you make a trust. It's literally just passing the legal title to person one, but denying them the benefit of the property and saying that the person who receives the benefit is another person. Okay? Why would you want to do this? You look like you're asking yourself that same question. Why would you want to do this? Yeah.
Like if you have like a child of some sort and maybe somewhere along the way, they pass and it's on. Like if you were sick and your baby was going to cancer or something and you have children, it's just you alone pass, you want to put somebody I trust just to hold the property until the children complete.
Yeah, that's exactly right. I see you guys asking me to repeat. I will repeat once I sort of say what has just repeat what's just been said. The question was, why would you ever jump through these hoops to create a trust? And the answer is, right, you may have a child, and that child may not be of age to handle their own affairs, but maybe you die, right? So the example was if you got sick, if you had cancer, if you knew you were dying, but you may just die, right? These are conveyances that you can make through a will as well. So you may just drop dead and leave your property in trust to someone to look after it for your children, right? So the request for a repetition was, as I understand it, what does a trust do? What a trust does is it assigns the legal title to person A, but person A holds the land for the benefit of person B. Okay? Does this make, now did you hear that? Did that make sense? Sure. Sure. Okay, well, I'll put that in the chat as well, Pierre. Okay. Got it. I will put that in just a second. All right, so this is what a trust is. And the words for trusts in Barbados and Belize are right there. Okay. All right. So, questions about trusts? What questions do you have about trusts? Great question. The question for those not in the room is, why would you do a trust as opposed to just a fee simple determinable that determines upon the child reaching the age of majority? Can anybody think of an answer? Yeah.
My answer to that would be that if it's a fee simple determinable, it would temporarily belong to that person A. But for a trust, it doesn't only belong to person A. That but in a determinable, they have certain rights or enjoyments to that land for that period of time.
Exactly. The purpose of the trust is to separate ownership from benefits. Okay, and the purpose of all of these is to separate ownership from benefits. The benefits are the equitable interest. So for example, right, let's say that the land in question is income producing, right? Maybe it's a going business or agricultural land or whatever, right? The trustee holds title, but all the income has to go to the beneficiary, right? So that's what it means to have equitable title, is you receive the benefits of the property. Whereas if you get a fee simple determinable, the trustee would get both the ownership and the income until it determined.
Other than that, it's a which contrast the evidence before the grant of
To the beneficiary? To the beneficiary, you mean? Well, I mean, the problem with that is, what if the beneficiary is not capable of managing the property, right? You may want someone to have control over how the property gets used to make sure that it is that it is protected and that it is used in a sensible way, right? So you don't want your 6-year-old deciding what's going to be grown on the family farm, right? So we're going to grow chocolate. The part after the separation of the ownership and benefits. I absolutely would, but I'm not sure.
I think what Travis was saying, I think right, what you said right after Travis answered. So for example, it separating. Basically what you said after Travis answered.
So, so the idea here, right, is that we want to make sure that the property is prudently managed while the person who we want to receive the benefits of it still receives the benefits. And so the reason why we don't use a defeasible fee is because we want to make sure that because we're concerned that unifying ownership and benefits through a defeasible fee would either lead to imprudent management or would deprive our beneficiary of benefits. Does that make sense now? So Pierre, the answer to that is trustees own the land. The trustee can do anything that an owner would be able to do, so long as the benefits of what they do flow to the beneficiary. Okay. Now, if you take the law of trusts or the law of administration of trusts from Dr. Yearwood, you'll talk a lot more about what it is that trustees have to do. I actually haven't spoken to him about this. I would assume he will talk a lot about fiduciary duties, because that's something that becomes very important in trusts. But the answer to your question is, as a matter of property law, the trustee can do anything that an owner would be able to do, so long as the benefit of it flows to the beneficiary. Yeah.
Okay, so they have the right to do anything an owner could do, but for the benefit of the city. But what do they get for being a trustee?
I mean, as a matter of common law, they get a good feeling in their heart. There's nothing that a trustee is required to be given to perform as a trustee. Now, as a matter of practice, in the year of our Lord 2020, or the year of creation 5781, trustees usually are entitled to a fee associated with their growth of the assets. So I'll give you an example that is personal to me. I am the survivor trustee for my aunt and uncle who have no children of their own. who live out in California and have assets, some assets. Part of the purpose of the trust is to provide for the education of the children of their nieces and nephews. So my kids, of whom there are none, my brother's kids, my cousin's kids, et cetera, et cetera, et cetera. That's the idea behind the trust. As the trustee, I am responsible for determining what my nieces and nephews' kids get paid for. So I decide if they're going to a college that I think the trust should be paying for. I decide how much of the trust's assets I'm willing to dissipate in any given year above and beyond whatever growth we achieve. In exchange for this, my fee as the trustee is 0.5% of all the growth of the trust. So any appreciation in value that the assets make, I get 0.5% of it. Now, none of this happens until both my aunt and my uncle are dead, which hopefully will be a very long time coming. But that's what trustees get, is usually the trust instrument in modern times provides for some sort of fee based on either a flat fee or based on the growth of the assets. Yeah.
You were saying something about how you choose where your activities to on those things, right?
Sure.
Wouldn't that be a decision of the trust or of the trustee? And that the person who gave you that trust, isn't that their decision to make and guess which one goes through?
So you are correct that the trustor has the power to make that decision. In this particular instance, that is a decision that is devolved to the trustee. So my aunt and uncle absolutely would have the power to say, we will pay for the education of the children of our nieces and nephews as long as they go to educational institutions that we attended, right? And that would deprive the trustee of that power, okay? But they have elected to devolve that power. They've elected to say, these kids can go to any educational institution they want and the trustee can decide how much he wants to pay, okay? But you're right that that power does lie with the settlor, and they have that, they do have the power to shape that in that way, okay? So didn't really intend for this class to turn into a law of trusts class, especially not a law of trusts in the US class. Okay, so there's some questions in the chat. Let me scroll up and make sure I've gotten all of them. What happens if the trustees have mismanaged the property? That's a question for Dr. Yearwood's class. Megan, you're asking something very similar. Kimika, the trustee absolutely can dispose of the property. It's just that the proceeds from that disposal have to go to the beneficiary. Okay? Okay. What?
I think that I'm not doing that. As trustees, they will need to work and I
Well, I have no comment on that.
What's the system of accountability?
Yeah.
That's probably a question for Dr. Yearwood's class. But here is sort of the 30,000 foot overview, right? Which is that the question is, what's the system for accountability? And that the 30,000 foot overview is that to some extent, the court sits as the system of accountability. And so you can have situations where beneficiaries sue their trustees and claim that the trustee has engaged in waste or has diverted assets to the trustee's use, you know, those sorts of things. But for the most part, like particularly if the beneficiary is a child or is mentally incompetent or is, you know, in some other way not able to look after their own affairs, A lot of times it's just, it really is trust. And you know, you should be careful about who you entrust property to. You know, don't do it to the guy you meet at the bar who buys you a beer. So, Michelle, the answer is that a trustee, this has gone a lot further down this road than I really wanted to go, but it's fine. Yeah, I don't know, again, now I really am talking about American law, so you should feel free to check out, but these are questions that you guys are asking, and I don't know what the Caribbean answers are, so I'm going to give you American answers. Feel free to ignore. In the United States, claims related to minors' trusts, the statute of limitations starts to run when the minor reaches the age of majority, precisely because of what Pierre is saying, that you know, minors frequently can't look after their own affairs. They may be sort of dependent on the trustee, and so they don't have the ability to bring suit for trustee misbehavior until they reach the age of majority. So if there's a 3-year statute of limitations and the trust is settled when the child is 6, the child can issue a claim for 15 years of mismanagement, because they'll be able to claim all through the 12 years before they reach the age of majority, and then for 3 years after that. So, so that's the answer. Can you change to a different person in the event that the person that you selected turned out to be untrustworthy? No, actually. Once you settle a trust, you no longer own the assets unless you settle it on yourself as the trustee, which you are absolutely allowed to do. Okay? But
don't you set some trust when you're dead?
Not only that, right? So this is, again, this is an American answer, okay? It is not uncommon for people to create trusts for all of their assets where they are the trustee, and then they designate a survivor trustee. This is exactly what my aunt and uncle did. I think it depends on how the trust is set up, right? So some trusts are set up to be perpetual, and some trusts are set up to terminate, okay? But it is not uncommon in the United States for people to create a trust, put all of their assets in it, they're the trustee, they're the beneficiary, but because there's now this trust out there, they no longer own any of their assets. And the purpose of this is to avoid probate. Because now, when you die, the trust just changes trustees and beneficiaries. And that is an outside probate pass. And so the estate no longer has any assets for probate, which of course can be quite handy for dealing with creditors or dealing with relatives that you want to cut out of your estate who may have objections to that, right? So this is why you might do these sorts of things, is to exert control over how the property passes and is managed upon your death. Whereas if you try and do this through a will, there may be people who would object, who may be able to convince the court to dispose of your assets in a different way. Okay? So Pierre's right. We're going way down the rabbit hole. But if this is something that you guys are interested in, I'm more than happy to like follow you guys down the rabbit hole. I'm not going to insist that we do the things that I want to do. Okay. So any other questions about trusts before we move on? Because we have not by any stretch of the imagination covered everything I want to cover today. But if this is what you guys want, then this is what we do. Okay? Okay, moving on. The second way in which we create equitable interests is contracts to create legal interests. So, in order to understand what we mean here, we need to transition to talking about what is a legal versus an equitable interest. Okay? And this was a question that was asked on Tuesday, and I promised an answer. And unfortunately, I don't have the hard answer that I promised. I have some things that I can state definitively and some other things that I can't. So we know that the 1925 Law of Property Act defines a list of legal estates and legal interests, okay? So legal estates are two, right? There's the fee simple absolute, and there's the term of years, okay? There are other kinds of legal interests under the Law of Property Act. Without I'm not going to throw them up on the board. They are not that important except to note that they are there. Easements, which are rights of access, right? The rent charge, which is a common law interest of basically rent forever on a freehold estate. So you would convey a fee simple absolute and retain the right of rent charge, and every year the fee simple absolute owner has to pay you a sum. And at this point in history, the sum is relatively nominal, but at the time that this was a common arrangement, it was it was 2 to 5 pounds a year. That could be quite a bit in the 1300s. In the United Kingdom, rent charges are in the process of being abolished. So they may not exist for too much longer. The mortgage is a legal interest in land. The statutory charge, which I was not able to figure out what it was, and the right of entry, which is not quite the same as a right of re-entry, but can be. And that's as good an explanation as I have, and I apologize for that. So under the Law of Property Act, these are legal interests in land. Any other interest in land is equitable. So if you have a contract to obtain one of these legal interests in land, that contract provides you with an equitable interest, an identical equitable interest. Okay, so in order for this to come into play, there are some conditions. Okay, so we already discussed you have to have a contract, you have to have a legal interest, that is created by the that will be created upon the execution of the contract, and you have to be capable of specific performance. Specific performance is a remedy. Oh, look, remedies. Specific performance is a remedy where instead of money damages, you actually get the thing that you are supposed to get. Okay?
I'm completely lost.
That's fine. I don't mean that's fine. I just mean I understand. So
I have no idea what's the link to the three things that you just listed to notebooks.
okay, so these are the requirements in order to get an equitable interest through a contract. Right? So you have to have the contract. Okay. It does not have to be in writing. This is a mechanism to defeat the statute of frauds. But you have to have a contract. The contract has to create a legal interest. Okay. Which means that we have to have the fee simple absolute or the term of years or the other interests that we talked about, right? The easement, the rent charge, mortgage, etc. And you have to be capable of specific performance. Okay? So, all right. Any questions about contracts as an equitable interest mechanism? Not nearly as interesting as trusts, I know.
These 3 points that they created.
Sure. You got to have the contract, right? You have to have some sort of agreement for performance between the two parties. The contract has to be an agreement to convey a legal interest. Okay, so this is most common with leases, okay? But you can have it with any legal interest, all right? Got to have a legal interest that is being conveyed. And there has to be the ability for specific performance. And this becomes relevant when the landlord executes a contract for a lease and then sells the property out from under the tenant. There is no longer the ability for specific performance. And so there is no equitable lease. Does that make sense now? Great, awesome. Sure, right? An example of the creation of an equitable interest, right? I assume using the contracts mechanism. Leases as legal estates must be executed via seal. So probably all of you rent, well, maybe not if you live at home with family, but if you live on your own, my guess is an awful lot of you rent your homes. Was there a seal attached to the document that you signed with that was described as your lease? There wasn't one when I signed mine. So that is a contract to execute a lease. And so if you have the contract, the legal interest, and the capacity for specific performance, we treat it the same as if it was a lease that was executed using the formalities of the statute of frauds and executed under seal, et cetera, et cetera, et cetera. Yeah?
So what do you mean by seal?
A little circle of wax with the stamp of probably a notary or a court, right?
So to the extent that it does not create If there's no seal.
If there's no seal, it creates an equitable interest. But we treat it as if it were a legal interest. Like that's what equity demands, is that we treat it the same. Okay.
So it doesn't create a legal interest. It creates an equitable interest.
That we treat as if it were a legal interest. And if this is confusing, yes, it is.
And this is when it doesn't have a seal.
Right.
So why whenever just call it a legal interest anyways, instead of not calling it a legal interest and then making it an equitable interest and then treat it like a legal interest?
Because the law does not authorize us to treat it as a legal interest.
Is it because we have no rights, like no legal rights to property? It's why I'm trying to contextualize this. Because like, I know like when you steal stuff, when you register it live, that means it's in your name already. And correct me if I'm wrong.
Yes, yeah. If you comply with the requirements of the statute of frauds, you hold legal title, and you own the property within the context of whatever that ownership is, right? So it may be a term of years. Yes, Travis.
Correct me if I'm wrong, but from what I'm getting from this explanation is that, for example, you buy a plot of land, go through all the proceedings to get it officially stamped with the wax. But for example, for halls, where we sign our and just even come to them, halls will be equitable but treated as legal because all the terms created by UB and the Auto British administration, all that would be their terms but treated with legal enforceability based on them making their laws to law, while the lease from a land or those things would be more of direct access of the legislation from the government. Does that make sense?
I don't want to comment on the agreement that you have with UE to live in halls. And the reason I don't is I remember when I was signing residency agreements as an undergraduate at the place that I went to undergrad years ago. It was specifically stated that this was not a lease, that I did not have tenants' rights, that this was an occupancy agreement and the university retained the right to throw me out at any time for any reason. So I do not want to comment on the agreements that you have with UE on the halls in case they are doing something similar. Okay. But if you live off campus and you have executed a contract for a leasehold, then if it meets these requirements, you have an equitable lease that we will protect as any other equitable interest.
I get that, but my question was that in the difference between legal and equitable interest, in that the terms made by someone in equity is not necessarily created by a sovereign or statute or from. And when you buy land or lease land, those kind of property can be more from those states or those sources. That makes sense.
Okay, I see what you're saying. What I'm going to ask you to do is, because we're out of time, so I want you to email me this question, and I will respond in the announcements forum so that everyone has the benefit of it, but so that I can think on it and sort of figure out what I think. Okay? Tell you what, I'll do that on Tuesday. Because this is stuff that we need to make sure that we have a grip on before we move on to the rest of for the next few weeks. So I don't want to move on from this until we understand it. Okay. Not always, but you can't, if you don't comply with the requirements of the statute of frauds, you can't convey legal title. And that's that much I can tell you. So anything that does not comply with the statute of frauds, the most it can create is an equitable interest. Okay. All right. Last chance for questions before we're gonna call it a day.
So it's may sound crazy,
No less crazy than anything else we've talked about today.
Can you look at it like how you would look at a relationship between a parent and a child, where a parent would create all these kinds of rules that the children have to abide by until they like how I'm trying to like understand how it does works, right? These rules aren't necessarily legal, these rules.
I would. So again, without commenting on the situation that you guys have with UE, my situation with GW, those many years ago, should best be construed as a contractual relationship where I agreed to abide by their rules, whatever they were, and to pay the money that they wanted me to pay. And they agreed to provide me with housing in exchange. And if I didn't comply with my end of the bargain, they could stop complying with their end. Does that answer?
So like a parent child, because that's what you see. Like your parent tells you something, you don't.
I would not describe it that way, but I think that I may conceive of the parent-child relationship differently. So, okay. So thanks so much, guys. I appreciate your patience and your hard work and your engagement, and we'll see you guys next week. So take care.
Have a good answer.
You too.